So, ladies and gentlemen, as a head of the research group, the impact of digital platforms and social media on freedom of expression and pluralism in Central Europe Professors Network 2021, and as the tutor of the Scientific Circle of Criminal Procedure Law at the Faculty of Law and Administration of the Cardinal Stefan Wyszynski University in Warsaw, and as a director of the Institute of Justice in Warsaw, I'm very pleased to welcome you at today's conference entitled "The Impact of Digital Platforms and Social Media on Freedom of Expression and Pluralism, View of Young Researchers." The conference is organized as a part of Central European Professor Network 2021. The Professor Network, with the active participation of experts from 7 different countries, in example, Czech Republic, Croatia, Poland, of course, Hungary, Serbia, Slovakia, and Slovenia, organizes this event with the primary aim to draw attention of the European citizens to the topic which are important and significant in connection with the future of Europe. The issue of digitalization and addressing its possible disadvantage from a legal viewpoint and crucial for Europe in 21st century. The main aim of this event is to enable young researchers to present their research results. The conference is organized as a dissemination event of Bartłomiej Oręziak, the member of the research group titled "The Impact of Digital Platforms and Social Media on Freedom of Expression and Pluralism." And at the conference, conference, there will be 2 key issues. First, analysis of the influence of fake news on the internet with regard to the freedom of expression and pluralism of opinions. And second, analysis of the influence of censorship on the internet with regard to the freedom of expression and pluralism of opinions. Speakers at the conference will be young researchers from various countries. I sincerely hope that the cooperation will bring positive results and will allow the exchange of knowledge about legislation and legal solutions regarding the impact of digital platforms and social media on freedom of speech and pluralism. At this moment, I would like to give the floor to Bartłomiej Oręziak, PhD student at the Faculty of Law and Administration of the Cardinal Stefan Wyszynski University in Warsaw, the member also the research group titled "The Impact of Digital Platforms and Social Media on Freedom of Expression and Pluralism." So on my side is all. I wish you all of you successful deliberation in the conference. Bartek, please, the floor is yours. Good luck, everyone.
Okay, thank you very much for the speech, dear director. Your Excellencies, distinguished guests, ladies and gentlemen, good morning. My name is Bartłomiej Oręziak, and in fact, I am a member of the Central European Professors Network 2021, exactly in the group headed by Professor Marcin Wielec, The Impact of Digital Platforms and Social Media on Freedom of Expression and Pluralism. This conference is my dissemination event in this project. I'm also a PhD student at the Faculty of Law and Administration of Cardinal Stefan Wyszynski University in Warsaw. I would like to warmly welcome all guests who have expressed their willingness to participate in today's international scientific conference. I also would like to welcome all speakers. This is looking to agenda. Of course, the first, dear director Marcin Wielec, and then Tomasz Bojanowski, Klaudia Łuniewska, Andrzej Bozinowski, Nate Urankar, Janos Szynek, Ewa Płocha, Janusz Tomasz Pap, Nowak-Wójcicic oraz Elżbieta Antosiewicz, Karolina Bać. Your Excellencies, distinguished guests, ladies and gentlemen, I wish you all the best so that your deliberation made during this conference will be fruitful and valuable for science. I think that the conference should be considered as started. Thank you very much.
Good morning, ladies and gentlemen. I am Maria Fluk-Pilch and I will be a moderator of this conference. It's a great honor for me to take part in that conference, so thank you for that possibility. I would like to please for taking care of the time discipline. I'm sorry because I know that it's very hard to do that. And I would like to highly apologize for any mistakes by my side. And I wish you all, ladies and gentlemen, good luck. So we will start with the first panel, and the first speaker will be Mr. Bartłomiej Oręziak. Mr. Oręziak will tell us about censorship legally justified in Poland, the impact of freedom of expression in pluralism. Please for your speech, sir.
Okay, thank you very much. Yes, ladies and gentlemen. Yes, this is also me, Bartłomiej Oręziak from Central European Professors Network and Faculty of Law and Administration of Cardinal Stefan Wyszynski University in Warsaw. In fact, today I will talk about censorship legally justified in Poland. It will be a perspective of the impact on freedom of expression and pluralism. Poland, as an EU member, European Union member state, is obliged to take into account EU law and comply with the judgments issued by the Court of Justice of European Union, hereinafter just card. Okay, this is in this putable fact resulting from Poland's international legal obligation. Another in this putable fact is that in the context of the correct interpretation of EU law, the ruling of the court are of a key importance, as it uses an autonomous interpretation to create or clarify the content of legal norms adopted by the EU legislator. Okay, it should be remembered that the EU jurisprudence system, unlike to the Polish system or another, is precedential and therefore lawmaking. This often leads to peculiar situations where on the basis of one provision or even part of it, an autonomous line of jurisprudence is built and fundamentally changing the current legal situation of the entity. In practice, these changes may be so far-reaching that there is a question of their compliance with the will of EU legislator, who in fact represents the will of the EU member states. Due to the both emphasized lawmaking nature of the court jurisprudence and due to the obligation of EU member states to apply EU law in accordance with the autonomous interpretation of the court, this issue is of a great importance in law, in science of law. Today I will talking about the issue of the admissibility of publishing content on the internet in accordance with EU copyright law. Resulting from Directive 2001/29, hereinafter just directive, In this respect, an appropriate interpretation of Article 3, paragraph 1 of this directive is of a key importance. This provision states that member states shall provide, this is citing, authors with the exclusive right to authorize or prohibit any communication to the public of their works by wire or wireless means, including the making available to the public of their works in such a way that members of the public may access them from a place and at a time individually chosen by them. As it turned out in practice of applying the directive, the point requiring the use of advanced interpretation techniques was and still is the concept of communication to the public used in Article 3, paragraph 1 of the directive. From the point of view of interpretation of this provision with regard to restriction on placing content on the internet due to copyright law, EU copyright law, of course, the most important is the autonomous interpretation issued in the judgment in the GS Media case. This is C-160 on 15, after just GS Media case. Ladies and gentlemen, the substance of the ruling in GS Media is to point out how the concept of communication to the public used in the directive should be understood. The composition of the card proposed to look them through the prism of the principle and factors indicated in the judgment. This refers to the principle of two conditions and the principle of individual assessment. The first one consists in the fact that the term communication to the public combines two premises that require simultaneous fulfillment. Fulfillment, this is the act of communication of the work. This is the first, and the second, sharing in public. While the second one requires a personalized assessment, which can be made after taking into account many complementary factors. The first factor identified by the card is the essential rule of the user and the intended nature of his action. He performs the act of communication when he's fully aware that if it were not for his operation, other internet users would not in principle have access to the protected work. Ladies and gentlemen, the second one factor is the very concept of public, while which assumes unlimited and at the same time, of course, quite a large number of potential audience. However, it should be borne in mind that the use of the term communication to the public requires that a protected work be made available through a different technology than that which was previously used. In case of technology identities, we are forced to refer to the concept of new public. So to make a protected work more accessible to a wider audience than it did before. The third factor is the consent of the copyright holder, as the card pointed out in its earlier rulings. If the consent is of an unrestricted nature, then it is to be accepted that such content includes all internet users as such. On the other hand, when it is limited in scope, we must appeal to the already mentioned term new public. The fourth and last factor, but the most important, indicated by the card, is the profit nature of the communication to the public. It is therefore important that the user publication protected work to increase their assets. It is professional, okay, or is it the opposite and does it without profit? Of course, non-professional. This is a key distinguish because in the first case, there is a presumption that the user knows or could responsibly have known that the protected work was published without the permission of the copyright holder. In contrast, in the second case, there is a presumption of opposite content, of course. In relation to both, there is the possibility of proving the contrary. In the light of the above, the CARD concludes that Article 3 of the directive must be interpreted as meaning that in order to establish whether the fact of posting on a website hyperlinks to protected works, which are freely available on another website without the content of the copyright holder, consists communication to the public within the meaning of that provision. It is to be determined whether those links are provided without the pursuit of financial gain by a person who did know he didn't know or couldn't know responsibly have known the illegal nature of the publication of those work on that other website or whatever. On the contrary, those links are provided for such a purpose, a situation in which the knowledge must be, of course, be presumed. Ladies and gentlemen, the outline example of censorship under the EU copyright law in Poland constitutes a legally justified censorship, where there is undoubtedly the control and restriction of internet users' activities, including their publication of content due to legal reasons. It should be emphasized that legally justified censorship only means that this type of censorship is based on binding law in Poland, and only this. It seems difficult to assess the justification as a whole, to assess this issue. After all, we are talking here about law legally established in the EU, which has been correctly implemented into the Polish legal order and then modified by the autonomous interpretation of the CARD. The same seems to be correct. EU member states have agreed to it by deciding to become a member of the European Union or by ratifying the changes to primary EU law. But an interesting question, in my opinion, is whether they were fully aware of its full consequences. In fact, it is not about the shame of action here, because it has its basis in international law, but about what substantive content is hidden under this shame. And even more importantly, whether this content is consistent with freedom of expression and pluralism on the internet, which standards are guaranteed in the Constitution of the Republic of Poland. I think that this is a good point of reference, because in Poland, it is the highest and unquestionable law. Freedom of expression and pluralism has been provided for in the Constitution of the Republic of Poland, and under the same legal norms, there is the principle of pluralism in this respect. However, this has not been done in one provision, but in many. Only the comparison of Article 14, 49, 53, 54, and 73 of the Polish Constitution with their proper interpretation is in particular Article 54 confirmed the statement. Therefore, it should not come as a surprise that in accordance with Polish law, it is only permissible to limit these rights and freedoms of an individual in such a way that does not infringe their essence. The normative basis of such restriction is provided for in Article 31, paragraph 3 of the Polish Constitution. Pursuant to this provision, restriction on the exercise of constitutional rights and freedoms may be established only by laws, and only if they are necessary in a democratic state for its safety or public order, or for the protection of the environment, public health and morality, and or freedom and the rights of others. Of course, any limitation. These limitations cannot affect the substance of freedoms and rights. This means that in Poland, the limitation of Article 14, 49, 53, 54, and 73 of the Polish Constitution may take place, but on strictly defined principle resulting from Article 31, paragraph 3 of the Polish Constitution. These principles fall into two dimensions. The formal dimensions require that the restrictions be introduced in the form of laws. This is what Roman calls lex not ius, of course. And the material dimension that it stated that this is necessary in the democratic state for its safety or public order or for the protection of environment, health, or public morality or the freedom and rights of other people. Both of these dimensions must be met together. Finally, I would like to share with you my reflection in this area. Legally justified censorship constitutes a direct restriction of the rights and freedoms provided for in the Constitution of the Republic of Poland. This is fact. The presented example of the censorship results from the implementation of Article 3, paragraph 1 of the directive to the Polish normative order is an example of this restriction. The transposition of EU law to Polish normative system was in the form of a law. So this means that the formal dimension of Article 31 of paragraph 3 of Polish Constitution has been correctly observed. It is clear that copyright protection is about the freedom and rights of others. That is, in fact, the legitimate claims of the copyright holder. Nevertheless, these restrictions may not infringe the essence of other freedoms and rights on the other side. In order to consider that it is justified and legal, it must be determined whether this limitation enables the effective achievement of the intended purpose of this restriction. It seems that the system of linking admissibility defined by the card ensure full achievement of this purpose, full protection of copyright on the internet, very strong protection. Secondly, and in fact, thirdly, it should be examined whether such strictly defined linking rules constitute a necessary measure. Necessary measure, it means that the least burdensome measure available to an individual, and whatever an appropriate balance was maintained between the benefit of this measure applied and the burden imposed of the individual. In my opinion, here the question is not so obvious and require an in-depth and multi-context analysis. In fact, an analysis that will not focus on generalities, but will analyze each card, each judgment, each card of Justice of European Union judgment separately. However, of course, this requires a much broader scientific statement. And this short reflection, I would like to end my speech and thank you very much for your hearing, for your attention. Thank you very much.